I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. Good morning. Are you Caden Fontanet? And this is 25 DCCR 1.
Right away, this sentencing hearing takes a serious turn. The defendant is hoping for probation, but prosecutors are about to introduce surveillance footage from the robbery itself. And if that video is as bad as they're hinting, any chance of a lenient sentence could disappear in a hurry.
759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
The state is, Judge.
Are there any additions or corrections to the report?
Not from the defense.
Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence?
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one.
No, Judge.
Make that states 2 because this one was the plea admonishment documentation, please.
I'm offering states two.
No objection.
States 2 is admitted.
Permission to publish, Judge.
Yes, sir.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough.
Did you catch that? The judge didn't need to see the entire video. Sometimes just a few moments of surveillance footage are enough to completely change the tone of a courtroom. Whatever was shown on that screen clearly left an impression, and that's not good news for the defense.
Would you switch that back to the other? Would you switch that back to the other?
All right, I thought I did. Yeah, back on camera image. Yeah, back on camera image. Oh, you want on 50? Oh, you want on 50?
Try one.
Well, HTML one is the laptop. Well, HTML one is the laptop.
Thank you. Okay, thank you. Any other evidence? Any other evidence?
Oh, Judge,
or witnesses?
Oh, Judge, just
Now comes one of the toughest jobs in criminal defense. Asking for mercy after damaging evidence has already been seen. The defense isn't denying what happened. They're trying to convince the judge that this young defendant is still worth saving. Do you think age and a difficult upbringing should influence sentencing in a case involving an armed robbery?
brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor. Just
Mr. Rojas, you may make argument first.
Thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing.
Watch the shift in strategy here. The defense focused on rehabilitation, but the prosecutor is about to focus on something entirely different: public safety. This is one of the biggest debates in criminal justice. Should courts prioritize giving offenders another chance or protecting the community from future harm?
And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that we've got options here, Judge. We can send him to prison or we can put him on probation. certainly he's on the road with, if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. There'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take.
That's a powerful moment. Prosecutors rarely use language this emotional unless they're trying to emphasize the broader impact of a crime. Notice how he's no longer talking only about the defendant. He's talking about victims, neighborhoods, and the message this sentence will send to everyone watching.
Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison, probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often.
This is the moment everything hinges on. Judges often reveal their thinking before announcing a sentence. And what we're hearing here isn't encouraging for the defense. The judge isn't just looking at the robbery itself. He's considering jail behavior, risk assessments, and the impact on the victim. All of those factors can dramatically increase a sentence.
I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking. I'm not in the habit of begging, but on behalf of this community, I'm begging that you send this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge.
25 years. The courtroom just went from discussing probation to handing down a sentence that will reshape this young man's entire future. The judge made it clear that the violence of the crime, combined with the defendant's behavior afterward, outweighed any argument for leniency. What do you think? Was this sentence justified, or should the court have taken a chance on rehabilitation?